Welcome to the debate. Today, we are turning our attention to one of the most significant constitutional amendments in American history, the 19th Amendment, ratified back in 1920. Now, this amendment prohibited sex-based discrimination in voting rights. And, well, it's often cited as the foundational marker of equality for American women.
It is undeniably a critical legal milestone, that's clear. However, the central question we really need to grapple with, I think, is whether that date, 1920, should truly be considered the definitive victory marker for American women's suffrage. Given the pervasive and, frankly, continuous disenfranchisement of millions of women based on race and socioeconomic status long after the amendment's passage, we have to ask if the constitutional victory really translates into historical reality for everyone.
Right. And I hold that it absolutely was the definitive legal and constitutional victory. It secured the federal principle of sex equality in voting. My argument, essentially, is that 1920 completed the legal framework required for full citizenship, and this allowed women to then shift their focus to battles of enforcement and intersectionality in the decades that followed.
I see. I guess I come at it from a slightly different angle. Focusing solely on 1920, for me, obscures the painful, very extended struggle of women of color and other marginalized groups. So if we define victory as the actual practice of universal suffrage for all women, well, then that success was secured much later. Primarily, I'd argue, through the Voting Rights Act of 1965.
Well, let me lay out my case first. The 19th Amendment represents the culmination of a 72-year movement. Its text is unambiguous. The right to vote shall not be denied on account of sex. This constitutional achievement established formal equality. It removed the explicit legal barrier that prevented half the population from participating in democracy. And this wasn't some minor legislative change. It was a federal command. The immediate legal pushback actually proves its significance. Think about it. The amendment's validity was challenged just 2 years later in the Supreme Court case Lesser v. Garnett, 1922. Maryland argued that its state constitution limited suffrage to men. But the Supreme Court unanimously upheld the 19th Amendment, ruling that the power of ratification was a federal function that, transcended any limitations imposed by state constitutions. This decision was pivotal. It cemented the fact that the sex barrier was legally and permanently removed across the entire nation, even in states that violently opposed it. And this constitutional success, it then galvanized post-suffrage activism, setting the stage for subsequent efforts like the introduction of the Equal Rights Amendment and the successful lobbying to include women as a protected group in the Civil Rights Act of 1964.
Okay, I agree that Lesser v. Garnett was crucial in establishing the federal supremacy of the 19th Amendment. That's an important point regarding the legal framework, absolutely. But we have to consider the lived reality of suffrage alongside the legal text. The traditional Seneca Falls to suffrage narrative you mentioned, well, it's widely recognized by modern scholars now as an incomplete assessment, mainly because it overwhelmingly centers the experiences of white middle-class women. I mean, for millions of women, and I'm talking Southern Black women, Native Americans, Mexican Americans in the West, the 19th Amendment was, frankly, largely symbolic. The legal text said they could vote, sure, but state-level mechanisms designed specifically to suppress minority access, things like literacy tests, poll taxes, restrictive property requirements, and just outright violence, they continue to bar them from the polls. For example, in the Deep South, Black women attempting to register often faced severe economic retaliation, even physical assault. In Texas, the Texas Rangers were, known for using violence and intimidation against Latino communities, which effectively discouraged their women from exercising the franchise. So if we are marking the point of victory for women's suffrage, surely that marker must be when women could actually vote without extraordinary peril or systemic denial. And that kind of effective enfranchisement, for me, points definitively to the 1965 Voting Rights Act.
Okay, let's address the deep moral stain left by the suffrage movement's racial strategies. They undeniably complicate any celebration of 1920.
Complicate is maybe an understatement. Is it truly possible to separate the constitutional text from the, let's be honest, the political compromise required to pass it? Mainstream suffragists, particularly leaders like Henry Blackwell, openly leveraged racism. They argued that enfranchising white women would, quote, counter the black vote, thereby preserving white supremacy in the South. The segregation, the strategic exclusion, the appeals to racial anxiety, these were pervasive, especially in the South and West. This demonstrates, doesn't it, that the movement's primary focus was securing the franchise for white women, which sort of undercuts the claim that 1920 represents a definitive victory for all American women.
I fully agree that the strategic exclusion and the use of racist rhetoric were, well, appalling and indefensible, no question. But here is the critical distinction I think we need to make. The moral failings of the activists do not negate the legal substance of the remedy they secured. The 19th Amendment fundamentally addressed a constitutional failure, specifically the failure of the 15th Amendment, which dealt with race, but explicitly omitted sex. The 19th Amendment provided a necessary federal tool, the legal tool, to challenge sex discrimination. Had this federal amendment failed, imagine, the subsequent decades of racial and class-based suppression would have been compounded by explicit lawful sex discrimination, right on top of everything else. We have to acknowledge that the federal mandate secured in 1920 removed the most fundamental constitutional barrier that applied across all races and classes of women.
But this neat separation you're drawing between the constitutional text and the reality of oppression, it seems to ignore the central concept of intersectionality, which is, I think, crucial for understanding the true persistent barrier to suffrage. You argue the 19th Amendment shifted the nature of disenfranchisement, leaving the fight focused solely on race and class barriers applied in supposedly non-gendered ways. I just don't buy that the barriers were truly non-gendered after 1920. I mean, consider the complexity faced by women in marginalized communities, where citizenship status itself remained the primary exclusion factor, and that factor intersected violently with gender. For instance, Asian Americans, many were barred from naturalization until as late as 1952 in some cases. That means their women, regardless of their status as residents, were inherently excluded from any 1920 victory. Similarly, Native American women weren't fully recognized under federal citizenship until the 1924 Indian Citizenship Act, and even then, state restrictions persisted well into the 1950s. And furthermore, even seemingly neutral economic policies were inherently gendered. We really need to talk about coverture laws. This archaic legal doctrine meant that when a woman married, her legal and economic identity was essentially subsumed under her husband's. She lacked control over her own wages. So, while a poll tax might seem race or class neutral on the surface, for millions of married women, it was a unique and particular financial obstacle precisely because they didn't have independent access to cash to pay it. The financial barrier to voting, therefore, was experienced acutely through a gendered lens, because that gender discrimination inherent in coverture remained legally intact long after 1920.
That's a compelling argument regarding non-citizenship and the persistence of coverture, and it really does illuminate just how complex disenfranchisement was. I grant you that. However, the very fact that you have to use this kind of complex intersectional analysis to explain the ongoing barriers, doesn't that actually support my position? The constitutional mandate of 1920 fundamentally changed the nature of the legal opposition. Before 1920, states could simply say, you are a woman, you cannot vote, period. After 1920, they had to get creative. They had to rely on these ostensibly neutral mechanisms, literacy tests, poll taxes, citizenship status, that, yes, disproportionately impacted racial and economic minorities. The fight was no longer, constitutionally speaking, against sex. The 19th Amendment forced the state-level battle to focus on those other, more complex intersectional issues. And that shift, I argue, is proof that the fundamental sex barrier was successfully removed. The fight became one of enforcement, which, yes, brings us back to the Voting Rights Act of 1965.
If the 19th Amendment was the definitive victory, why do we need federal marshals? Why federal oversight? Why specific mechanisms like preclearance under the VRA? All just to ensure that women of color in the South and West could actually register and vote? The VRA and its 1975 expansion, which importantly included coverage for language minorities, these successfully dismantled the systematic voter oppression of the Jim Crow South and restrictive Western policies. It was the mechanism that effectively allowed women of color to exercise the franchise promised, yes, but denied in 1920. And, black women leaders played a pivotal organizing role leading up to the VRA's passage. They often capitalized on the fact that they were sometimes perceived, rightly or wrongly, as less vulnerable to physical assault and immediate economic repercussions compared to black men who tried to organize. The VRA significantly increased representation and access for women as a whole, marking a much more substantive victory, I think, than the purely formal one in 1920.
I see why you'd frame it that way, thinking that the VRA represents the point of substantive access. But it can't be considered the fundamental victory over sex discrimination itself. The VRA was essential enforcement of rights that already existed legally speaking. But the 19th Amendment was the legal enabling factor. You simply cannot enforce a right that hasn't been legally established first. Moreover, the 19th Amendment enabled the subsequent political power that we observe today. We have concrete data showing that women's voting participation consistently exceeded men's starting around the 1980s. And this gender gap, it's fairly consistent across racial lines, demonstrating that women, regardless of race, are generally more likely to exercise the franchise once the combined legal and systemic barriers are removed. And perhaps, most crucially, Black women actually had the highest level of voting turnout among all demographic groups in both the 2008 and 2012 presidential elections. Now, this shows the ultimate effect of expanded rights. That is, the VRA enforcement layered over the 19th Amendment foundation produced measurable political power that truly redefined the American electorate. The foundation, well, it had to come first.
That's an interesting point about the turnout data, certainly, though I might frame its implications differently. Because the persistent struggles we still see today demonstrate that the legal foundation laid in 1920 was insufficient precisely because women's rights are still acutely vulnerable to seemingly non-gendered administrative policies. I mean, just look at modern voter ID laws. They're designed to be ostensibly neutral, right? Yet they disproportionately challenge African Americans, Latinos, and low-income groups. Okay, but studies also show these laws uniquely impact women because of name changes related to marriage or divorce. The problem is that administrative complexity, a seemingly small hurdle, can literally stop a voter. Data from the Brennan Center for Justice shows that only about 66% of voting-age women have an ID that perfectly matches their current legal name. This is a very real, modern, and distinctly gendered obstacle. We saw those high-profile examples of this in Texas recently, where prominent women like Judge Sandra Watts and even State Senator Wendy Davis faced bureaucratic hurdles simply because their ID didn't match their legal name due to marriage or divorce. This proves, I think, that the battle is far from over. And when we celebrate 1920 as the definitive victory, we risk ignoring the persistence of these administrative and bureaucratic barriers that often intersect race and gender. It reinforces the need to prioritize the persistent intersectional struggle that continues today, rather than marking victory prematurely.
But the modern focus on intersectionality, which is absolutely crucial, I agree, for achieving full substantive equality, it's possible precisely because the constitutional sex barrier was dismantled in 1920. That foundational success created a new political landscape. It freed up subsequent generations of scholars and activists to analyze and address the more complex, systemic, intersectional forms of oppression. Think about it. If we hadn't secured 1920, the battle today would likely still involve fighting state constitutions that explicitly barred women from the ballot box just for being women. Dismantling that explicit constitutional sex bar was the necessary prerequisite for shifting the fight to these more nuanced, systemic barriers, which we can now analyze using concepts like intersectionality. That legal prerequisite, in my view, makes 1920 the definitive victory marker for achieving formal constitutional equality based on sex.
I can concede that the 19th Amendment provided formal equality on paper, but the long, painful history of voter suppression, from blatant Jim Crow mechanisms to subtle modern administrative hurdles, makes it impossible for me to call 1920 the definitive victory for all American women. It was a victory for the principle of sex equality, yes, perhaps, but not for the practice of universal suffrage for women.
And I maintain that the 19th Amendment remains the key marker of success for achieving formal citizenship rights for women based on sex. It provided the essential legal basis, the constitutional mandate, for every subsequent legal and political battle women waged for greater access and representation, right up to and including the fight for the VRA itself.
Well, ultimately, our discussion certainly confirms that understanding the evolution of women's voting rights requires recognizing both things. The monumental constitutional milestone of 1920, yes, but also the continued, complex, intersectional struggle against systemic oppression that extended for decades beyond its ratification, and arguably continues in different forms today. The victory timeline, I believe, simply cannot stop at 1920 if we are to truly honor the diverse and often denied experiences of all American women.